Hey there, everyone. Josh Crowfoot here, Crowfoot Law Firm in Chattanooga, Tennessee. I'm a commercial real estate lawyer, and we're here on day 16 of Commercial Real Estate 101. Today, we're going to be talking about the letter of intent. And a letter of intent is a document that the buyer and seller will enter into prior to signing a purchase and sale agreement to memorialize the material terms of the deal. And while the buyer and seller can enter into a letter of intent directly with one another, typically it's a document that's prepared by a broker for one of the parties. So it could be the seller's broker, it could be the buyer's broker, and it will lay out material business terms. So the purchase price, the amount of the earnest money deposit, when the earnest money deposit is going to get paid, the length of the inspection period, whether or not the seller is going to allow the buyer to extend the inspection period for a period of time, say 30 days. If additional earnest money is paid, say $10,000 to extend, it'll discuss whether or not that money is refundable or applicable to the purchase price. And it'll typically also have the closing date. So it could be 30 days after the inspection period expires. Typically, there's not really much in the way of legal terms that are placed into the letter of intent. They can be there. They're typically not there unless the deal is very large, the parties are very sophisticated, and they've done enough negotiations where they know that there are certain things they want to make sure are included in the LOI. The LOI is not the gospel. It puts down the main terms, but the lawyers will still negotiate the purchase and sale agreement, but they will give deference to the terms in the LOI. What's incredibly important with an LOI is that you make sure you put in big bold letters that it is not binding and that it is merely an offer to discuss terms and that nothing is binding until an agreement is signed by both parties. That's important because under the statute of frauds, you can have an agreement by just one party agreeing. So if there's a sale of real estate, it's in writing, and the party to be charged has signed it, you might be on the hook. So